Good morning, Founding Fathers. My name is Jason Headingstutter, and I'm joined by my lovely TAs, Alexander Harris and Andrew Cho. What a great day! Today, we're going to be talking about the amazing Supreme Court case McCulloch v. Maryland. Remember, this is one of your required cases for the AP exam, so listen closely to deserve victory. Let's have Andrew give us some background information about the case.
So Americans in the early United States despised any sort of federal bank, as they felt it was taking advantage of them by competing with local banks and because of the government's perceived corruption. Due to its unpopularity, the first Bank of the United States was allowed to expire in 1811. The Second Bank of the United States was chartered in 1816 in an attempt to restore the financial stability of the U.S. after the War of 1812. Even with its reasonable intentions, it was once again unpopular, as a total of 8 states attempted to either tax or regulate the federal bank. James McCulloch refused to pay the tax the state of Maryland imposed on his branch, and the legal case was taken to the Supreme Court. Ultimately, this landmark case revolved around interpretations of the Constitution and the reaches of the necessary and proper clause.
Wait, so you're telling me that this case dealt with different interpretations of the Constitution?
Yes, I am.
Excellent. I'm sure you know what time it is. That's right. Do you have it with you? Take out your Constitution, Founding Fathers. Let's look together at page 7 under Article 1, Section 8 to find the necessary and proper clause. Ooh. And now let's look at page 16 where we can find the supremacy clause in Article 6. And we may even need to turn to page 23 where we can find the 10th Amendment. Alex, can you break down what these three clauses say and how they were applied to the case?
Sure. So Article 1, Section 8 is known as the Necessary and Proper Clause. It allows Congress to go beyond their enumerated powers as long as whatever they are trying benefits the nation. Article 6 basically says the Constitution, and therefore the federal government, is the supreme law of the land. And finally, the 10th Amendment declares that all powers that aren't delegated to the national government are reserved by the states. The real debate in this case comes from if the bank was even allowed to exist in the first place, and if the states were allowed to tax the branch that operated within their own borders.
Thank you, Alex. What do you think the Supreme Court ruled? Go ahead and think about it for a second. All right, I'll spoil it. The court unanimously ruled in favor of McCulloch, declaring not only that the federal government has the proper authority to create and maintain a national bank, but that states cannot interfere in federal affairs by taxing the bank.
Exactly. So the court acknowledged that while creating a bank is not within the enumerated powers of the Constitution, Congress can under Article 1, Section 8. The court declared that since nothing in the Constitution prohibits a national bank, Congress can create one if it decides to execute other enumerated powers. The court also ruled that states cannot tax a bank because Article 6 states that the laws of the United States, at the federal level, shall be the supreme law of the land. Just as McCulloch argued, the majority opinion states that taxing the bank impedes the functions of the government.
Wow, isn't that cool? Check out this quote from my buddy John Marshall, a great guy, by the way. The states have no power, by taxation or otherwise, to retard, impede, burden, or in any manner control the operations of the constitutional laws enacted by Congress to carry into execution the powers vested in the general government. Look, it's right there! Do you guys remember that word precedent? It's a pretty important word. Scoot closer to your neighbor. Actually, don't do that. It means like an example of something to be looked back on in the future. This landmark case becomes a precedent for the relationship between the powers of the federal government and the states. It defined the supremacy clause as we know it and was one of the first cases focusing on how far the necessary and proper clause can stretch. That's the bell. We'll pick this up tomorrow, Founding Fathers. Have a great day.